Good morning. We will go ahead and get started with this webinar since we are right at 11 o'clock today. Just as an FYI, we are recording this one. So if you need to watch it at a later time or share with anybody else, it will be on my YouTube page. Today's topic is going to be tips for ending a business relationship. So these are things that business owners need to know when they're going to end a relationship, or even if you're not a business owner, if you just are in a relationship of doing business, then we want to make sure that you understand what needs to happen if you're going to end a relationship with one of your vendors, one of your clients, or those type things. So this is your first time tuning into a webinar with me. My name is Lauren Ward. I'm an attorney with A Business Law Firm at 1989 South Pine Street in Spartanburg, South Carolina, and I practice in business law and estate law. I'm a graduate of the University of South Carolina and the USC School of Law. And like I said, my practice areas are business planning, estate planning, and Medicaid planning. So today we're going to talk about when we're in that business relationship, what do we need to look at? Things like contracts. Is there going to be debt collections or lawsuits involved? And what about non-disclosure agreements and non-compete agreements? So the first thing, you think, I cannot work with this client anymore, or I cannot work with this person, this vendor anymore. It is just not working out. They're causing me way too much stress. What should I do to terminate this relationship? Well, the first thing is, if you have a contract, pull that contract out, because you are going to need to review it to see what the terms are in it. So the first thing that happens is there a termination clause? So does it say that this contract can be ended early, or does it say this contract is for a year? And if you don't go the whole year, what has to happen? If there is a termination clause, how much notice do you need to give? Most of the time, it's usually 30 days notice in a lot of basic contracts, but each contract is different. And how do you give notice? That's another thing too. You can't just call them up and say, I'm ending this contract. Sometimes you have to send notice in writing, and it has to be sent like by FedEx with return receipt or certified mail return receipt requested. So it's important to understand if there is a termination clause and you are allowed to terminate the contract, to make sure you actually terminate it with the proper notice and that you've given the time that you need to give before you terminate. But say there's no termination clause, or it is going to be 2 years out before you can terminate this contract, and you just can't handle that. So we got to look at in the contract, what happens if you breach? Usually there's a section inside of your contract that deals with if someone goes into default. So in these situations, we have to look at what happens if you breach the contract. What are your damages? Are there clauses in there for like punitive damages, which mean they're there to punish you? Are there clauses in there for liquidated damages, which means you've already agreed to a set damages amount? So it's important to understand what are the damages there. If you're breaking a lease, in those situations, if you look at the statute, a landlord has to make the effort to release the building, so you won't be charged for your whole rent. But we need to look at the contract to see what it says and to see those damages, and to see if there's things like attorney's clause fees in there, to say if you lose and you breach this contract, they bring a lawsuit against you and you lose, you're going to be paying attorney's fees, court costs, and those type of things. So it's really important to look at the contract and what is in there if you go into default or in the contract early. You also want to look, when you're looking at a breach of contract, about things like trade secret violations. So if there's trade secret language in there that, you're obligated to keep these trade secrets, things like intellectual property rights, if there's copyrights, patents, trademarks involved, who owns those? Is it you? Is it the other party? What happens with that? And you do need to look about if there's non-competes and non-solicitations, which we'll talk a little bit more about those in the next slides. But those are the big things to look at. And the biggest thing is this contract in your business name or your personal name, which makes a huge difference. So if it's in your business name, that means they're going to sue the business. And as long as you're running the business properly and not doing anything to pierce the corporate veil, which we have another webinar on, and we'll probably cover that topic again in the future. But if you're doing everything to not pierce the corporate veil, then they can just go after the business and not your personal assets. So they can't come after your assets held in your individual name. But if it's in your business, if it's not in your business name and it's in your individual name, then that is something where they can come and sue you personally. They could look at coming after some of your personal assets. So it's really important to understand who you sign that contract on. As a business owner, you want to make sure when you're signing contracts, you sign them on behalf of the business. So like for me, Lauren Ward, member, a business law firm, LLC. So I'm signing it on behalf of a business law firm. I'm not signing as Lauren Ward, individual. I'm signing as Lauren Ward, member of a business law firm. So and if you, maybe you're not an LLC, maybe you are a corporation. So you may want to sign it John Doe, President, John Doe, Inc. So that's important to make sure that you always have your contract signed in your business name, to know that they're only coming after your business assets. So what about those times you have a business relationship, but you don't have a contract? So we kind of want to look at how your business relationship works. Do you have some verbal agreement in place that they could argue as a contract? And if you got into litigation, they could argue that there's a contract. We do have what's known as a statute of frauds, which says certain contracts have to be in writing. But then if there's things like part performance, sometimes those verbal contracts can get in. So it's important to understand, was there a verbal contract in place that maybe you've said things agreed to that they can bring up? And looking at the relationship between the parties. Do you pay this person monthly for their services? Do you pay them job to job where maybe it's a lot cleaner to cut it? Or is it like an ongoing service thing where maybe you have to terminate it at the end of a month or end of like some type schedule that you have with this person? And kind of what's your expectations moving forward? Do you want to plan on keeping any type relationship with this person? Maybe it's just you got to cut them from this job. Maybe you're a contractor and you can't have them work on this house you're doing, but you want them to be there for projects moving forward. So you have to think about the overall, what's going to happen with this business relationship. And that's something you as a business owner need to think about. But you do need to look, if there's no contract, was there something that said verbally they could argue as a contract? How is your relationship working? Do you do things on certain basis, certain times of fees for products? Like, do you always just say, hey, I'll buy 100 widgets from you for $100 and that's one transaction in? So really there's nothing to move forward with. Or is it, I'll pay you $100 every month, you keep supplying me widgets, where you're probably going to need to give them notice. In contracts, a lot of times we use the term widgets just for things. But that's something you have to look at in your individual situation with the parties. I think the best way to avoid this is having that contract in place ahead of time, but sometimes you don't, and you have to look at the way the parties have interacted. So this is stuff you have to think about the pros and cons of your actions with ending any type business relationship. And you as the business owner need to weigh those pros and cons yourself. Make a list of it. But things you need to consider is, how will terminating this contract impact your business? So is this going to really hurt your business? Is this going to impact your relationship with under vendors and those type things? Did you sign this contract in your business name so there's nothing going to come after you individually? And making sure you're following those corporate formalities, which we've talked about, to make sure we're not having issues with piercing the corporate veil where they could come after your personal assets. Things you also need to look at, like we've talked about, are you going to have to hire someone to collect debts from this person that they never paid for you? Or is someone going to try to collect against you with these debt collection lawsuits? And are there any non-competes and non-solicitations that could impact you being able to have income in the future? So those are things you all have to weigh about terminating any type of business relationship. And some of it isn't always the legal side of it, but just your business side of it is, how is this business going to be handled moving forward? And is this going to impact me in the long run? So sometimes when a contract ends or if somebody breaches a contract, you're owed money at the time of the contract ending. And so if you're trying to collect debt from someone, debt collections do require a civil lawsuit. It depends on the amount of damages if we're going to file it in magistrate court or circuit court. $7,500 and less is magistrate, over that is circuit court. And there's a different process in magistrate and circuit court. Magistrate is usually quicker. It's not as formal in a lot of ways, where circuit court can get a lot more formal, a lot more bogged down in things like discovery and mediation and all things that we have to go through as part of a lawsuit. So depending on the damages and knowing that lawsuits can be expensive, sometimes the basic litigation lawsuits, very simple litigation lawsuits, are anywhere from, $3,000 to $10,000 possibly. So knowing litigation is an expense. And if you had in that contract, you get attorney's fees and court costs, knowing that makes a difference, because the judge could award you those attorney's fees and court costs, which could be a reason you may want to litigate sometimes when other times you don't, because if the damages are $5,000 and you're going to spend that in attorney's fees, is it worth it to do it? So knowing when you're in the business relationship, if you're going to have to deal with these debt collections, weigh in the pros and cons of moving forward with it. And if you do owe money to a person, knowing that if you don't pay the debt, they could try to come after you and get a judgment against you. And that could really hurt you in the future, possibly with getting loans. Those judgments have to be paid off. And understanding what it means to have a judgment against you or your business is important. Because it does make a difference with credit scores, going to get loans, when people are looking at investing in your business and those type things. So it's really important to understand the financial sides of it if money is owed at the end of a contract. So a lot of times in contracts, we have clauses known as non-solicitation and non-compete. And these are really important to understand what they are. So if you have a non-solicitation clause that's in that contract you're terminating, this survives the termination of the contract typically. So it means that you cannot go after their clients or their employees. This is a good clause to have in a lot of situations, because you don't want somebody coming after your client. Like maybe you've hired this independent contractor and then they're going to try to come take your clients away. You want to have this non-solicitation language in there to protect you in that situation. And these do survive on the end of the contract. But on the reverse side, if you're starting your new business, you have to be aware that you're not supposed to go after those clients, and you're not supposed to go after the employees of your prior contract you've had with this person. Now, a client has the right to choose who they want to be with, especially in professional things like when law firms break up. You as the client have the right to decide if you wanted to be with one of the attorneys they left. You have the right to go be with that person. Same thing with like CPAs and those type professions. You as the client have the right to decide who you want to work with. But you can't actively solicit those clients if you have this in there, and you can't solicit those employees. One thing to notice is non-solicitations do need to be limited in time and scope. So typically it's like, you can't come after my clients for 3 years or something like that. If they're too overly broad, the courts are going to strike them down. And so they're not going to uphold these non-solicitation agreements. What is a non-compete? Those are in a lot of agreements too. This means you cannot form a competing business. So if you're in the business of an auto mechanic, you can't go next door and open this new auto mechanic shop, because that's a competing business. Now, once again, non-competes have to be limited in time and scope, just like non-solicitations. So typically they need to be limited to what the business is. Like you can't say you just can't open any other business. So if you're an auto mechanic and you want to go open a chicken shop or something, you want to go sell fried chicken in a restaurant, then you have the right to do that. They can't tell you can't open any business. It has to be limited to what that business is. It has to be limited in time. So usually 2 to 3 years. When you start expanding time, the courts are going to strike that down because of it being too broad, because courts want to make sure people have a right to earn an income, and it has to be a geographical region. You can't usually say all of the United States or even all of South Carolina. If you're just doing business here in Spartanburg, usually you can say within 30 miles of my business. those type things to really limit it. If they're not limited, the courts will not uphold these typically. So that's something, whether you're the breaching party or not, you have to understand what this non-compete means. And so if you have a non-compete that's too overly broad and the courts strike it down, it's not doing you any good. So making sure the terms of it are actually terms the courts would enforce, and knowing if you're the one wanting to compete, is the court going to enforce this non-compete or not? What are they going to do? Are they going to sue me? And understanding if you're really breaching it, they can sue you and get an injunction to stop your business. So it depends on the language of it, if it's too broad or not. But it's really important to understand when you have these non-solicitations and non-competes, how this impacts your business relationships. So these are kind of tips if you're going into a new business relationship, so we can avoid having to end them with all these questions in place. Have a contract in place so everyone is aware of the terms. Have clear termination terms, clear damages terms. Everything you have in that contract, you need to understand too. Don't just fill a contract. People will go online and find some random template that's full of legal jargon and not really know what it means. Make sure you're understanding the terms of the contract. Make sure if you're having us draft the contract for you that we go over it with you so you understand those terms. But having this contract sets clear expectations from the start of what this business relationship is going to be. And it also makes sure you set limitations for yourself so you don't have to continue these relationships that aren't working for you, that are dragging you down, that aren't an asset to your business. Having these things thought out ahead of time. And anytime you're entering into business with someone, you got to think of that worst case scenario. If things go south, what are we going to do? This is even for things like maybe you're already in business with a partnership. There's two of you in business together. Y'all need to have that operating agreement or those bylaws in place that deal with what happens if we have a disagreement. What happens if we want to go our separate ways? Anytime you're having a business relationship, whether it's inside of a business or with a third party, you want to set out these clear expectations, and you have to go into it and think about the worst case scenario. Hope it never happens, but to plan for the worst and hope for the best type situation with these business relationships. And that's why it's important to have all these contracts and those type things in place. Contracts, operating agreements, independent contractor agreements, employment agreements, any situation when you're dealing with someone else, it's important to have those contracts in writing. So ending the relationship, if it comes to that, there's clear terms, clear expectations of what's going on. So you're not going to be overly, it's still going to be stressful. Anytime you're in a business relationship, it's going to be stressful. But you're not going to have the stress of what's going to happen, because we know what's going to happen because we've laid out all those clear terms. So that's it for our webinar today. We just wanted a quick overview of this, knowing what to happen when you do want to end those business relationships. And if you're ever worried and you need somebody to read over your contract, or you do need to enter into litigation to deal with this, we at a business law firm are here for you and happy to help you with those questions. Once again, my name is Lauren Ward. I'm an attorney with a business law firm in 1989 South Pine Street in Spartanburg. Our phone number is 864-699-9801. And my email is lew@abizlaw.com. And we would be happy to answer any questions for you on this. Or if anybody has a question now, feel free to ask. Well, thank you for joining us, and thank you for attending. And if you, we'll be putting on another webinar in about a month, so definitely feel free to join in on that one. I usually post them on our Facebook page, LinkedIn page, and send out an email. So definitely join us for the next ones. Or if there's ever any topics you want to hear covered in a webinar, feel free to shoot me an email with some of those, and I'll be happy to look into covering those topics. I hope you all have a great day, and thank you for joining us today.